In view of the foregoing discussions and authorities relied upon, this court is satisfied that the learned trial court has correctly appreciated the evidence on record and arrived at the finding of guilt. Appeal stands dismissed. Yes.
Submission item 2.
May I seek your Lordship's indulgence in mentioning part 2, item number 9, my
The
Lord.
rest of the pages I'll sign later, okay? Other pages. Yes, part 2.
Item number 9. Yes, my Lord, if this matter may kindly come up as a fixed item tomorrow, if permitted.
Tomorrow. Okay. Item 9, huh? Tomorrow, fixed item. Yes.
Oblige.
May I seek your Lordship
Yes.
indulgence in mentioning part 2, item number 11. May this matter be taken on Thursday?
Thursday.
Yes, Your Lordship.
Okay. Item 11, Thursday.
Thank you, Your Lordship.
Yes.
Submission item 2.
May I please, Your Lordship. My Lord, my opponent counsels are not present, so this case may come up again this Thursday, my Lord. All pleadings are all complete now. Can be,
You are for the petitioner?
yes, my Lord.
Learned counsel for the petitioner, Mrs. Saranso is present. Stop. However, none appears for the respondents today. So please the matter again on Thursday.
This Thursday.
This Thursday. Okay. Give the date, huh? 14th. Yes.
Right, my Lord.
Item number 3.
May it please your Lordships, I appear for the appellant on behalf of my learned senior, Mr. Arlen Rumbrata. My Lord, on the last occasion, that is 23/4/26, an objection as to maintainability of the present appeal was raised by the learned public prosecutor on the ground that the sentence imposed does not exceed 7 years in reference to section 415 subsection 2 of the BNSS. And we are aware of the appellant had expressed intention to withdraw the appeal. However, on the last occasion, the learned, this honorable court had expressed a prima facie view that the present appeal may be maintainable under section 415 subsection 2 of the BNSS, and was pleased to grant opportunity to both sides to examine the provision, address further submissions on the question of maintainability. On top of that, my Lord, upon careful scrutiny of the statutory provision and scheme, I respectfully submitted that the present appeal is clearly appealable under section 415 subsection 2 of the BNSS.
Yes, because POCSO court, special POCSO court is a sessions court, isn't it?
Yes, my Lord.
Yes. The appellant shall file the necessary IA within a period of 1 week. Within a period of 1 week from today, and thereafter list the matter after 2 weeks. Yes.
Item number 4.
Your Lordship, according
Yes.
to the information I've received, the order has been complied with. This contempt matter may be closed.
Closed. Okay. Learned counsel for the petitioner submits that. That means order has been complied with. That the.
Payment has been made.
Okay, 1 minute. Counsel for the petitioner submits that Where have you given that, the order and the WP number?
64 of 2017.
That the order dated 21/8.
Lordship.
That the order dated 21/8, that the direction passed in 21/8/2019 in WPC 64 of 2017 has been complied with, and accordingly prays that the matter may be closed. So, as a result, the petition is disposed of, is closed and disposed of. Yes.
Obliged.
And give the names of the councils appearing.
Item number 5.
Lordship, in this case,
Yes.
only respondent number 2 has filed affidavit, counter affidavit. So the rest not
The other
filed.
have not, the other respondents
For
have not.
respondent number 1, I may be given 3 weeks time for filing.
Lordship, it was filed in 2024. It's already past 2 years, and
Yes.
they have not filed.
What happened?
They-
I think several adjournments have been
Yes.
granted because of this, 2024.
Lordship,
Yes.
I'm appearing for respondent number 6, and my senior, who is the leading counsel, is out of station, and I'm praying for 2 weeks' time for filing our counter affidavit.
Okay, last opportunity, huh? The learned senior counsel for the petitioner is present. Stop. The learned counsel for respondent number 6, as well as the learned CGC, prays for 2 weeks' time to file their affidavits. And learned, you have already filed. Okay. Learned counsel, Mr. Samuel Changte or Kangte? Changte. He has already filed his affidavit on behalf of respondent number 2. So accordingly, the other respondents are granted another 2 weeks' time as a final opportunity to file their affidavits. Stop list after 2 weeks. Yes.
Item 6.
My lord, this matter has been settled in the mediation. However, the records of the mediation are not in the file, I think, my lord. So I think the records of the mediation have to be called.
Yes, that has to be called, and on the basis of that,
Yes.
this court has to pass the order.
Yes.
Learned counsel for the petitioner, Mr. Surgeon is
Zoram
present. Zoram Chang is present. So it is submitted by learned counsel that the matter has already been settled in the mediation. However, the mediation records are not before this court. So accordingly, the registry is directed to place the mediation report before this court, and list the same after 1 week.
Yeah, next week, my lord. Next week.
List the same next week. Yes.
Obliged, my lord.
Item 7.
May I please, your lordship, my lord. Also, the opponents' counsel are on leg.
They are not appearing.
Yes,
Oh, on leg.
On leg.
Okay.
It may be pass over as last item, my lord.
Okay. Pass over for the time being. Huh? Call after some time. Yes.
Orders. Item 8.
Lordship, in this case, respondent has filed IA for extension of time for compliance. So the IA is placed before
Court number 1.
court number 1. So it should be clubbed together.
It should
If
be
I'm not
clubbed
mis-
together actually.
Yeah.
Hmm.
So if I'm not mistaken, in last 4 days, it should be clubbed together. But
Yes.
however, they placed this case
IA
before you, Lordship.
IA number?
IA number
IA number 26 of 28 of 2026. It's
20
listed as item 11 in
28 of-
today's list.
Okay, 28 of 2026. Okay. Learned counsel for the parties have made a submission that an IA has been filed in connection with the instant case, which is registered as IA 28 of 2026, and the same has been listed before before court number 1 today as item number
11, Your Lordship.
item number 11. Stop. The registry shall club this petition along with the IA and list the same before court 1.
Yes.
List the same before court number 1. Okay.
Sir.
Item number 9.
Okay, or you can send it to court number 1, the record. No? Because they are saying that it is listed as item 11 today in court number 1, the connected matter.
Lordship, I'm appearing on behalf of my senior Victor Eralte, and he is still on leave, so may this matter be listed tomorrow.
No objection, Lordship.
Learned counsel for the respondent number.
1.
Respondent number 1, praise for listing the matter tomorrow. Stop. Learned counsel for the petitioner has no objection. Stop. Pass over for the day. Okay.
Item number 10.
Same order.
Lordship, same order.
Okay, same. Tomorrow.
Item number 11.
Item 11 also same, I think.
No, Lordship, we are
Oh.
ready for that. There is a delay of there is a delay of 406 days in filing the special leave petition. This is an appeal against the acquittal.
Okay.
Acquittal order was passed by the learned CGM Champai. And this is regarding the gold case.
Regarding what?
Gold case.
Gold.
Gold. And the respondent was acquitted on the ground that the CIS article, the gold, was not produced before the magistrate, among the others. And there is a delay of 406 days. I've already mentioned, Lordship.
You have to get over that hurdle first.
Lordship, yes.
So what are your grounds?
May I take Lordship to page 10 of the IA number 41 of 2025. Page 10, paragraph 2.
Page.
May I read, Lordship?
Yes,
Page 10.
Yes. Let's see.
A. That the learned Chief Judicial Magistrate Champai had passed an impugned judgment and order dated 25/01/2024 in the case of Union of India versus Bol Thangpuyi. In fact, the impugned judgment and order dated 25/01/2024 was received by the Office of the Assistant Commissioner, Customs Division, Aizawl on 15/3/2024. As such, 50 days had gone unintentionally from the date of judgment and order dated 25/01/2024. Lordship, I have annexed the extract copy showing that the date of the receipt of the said impugned judgment and order. I have annexed at page 18. Lordship, page 18.
Page 18.
18. In the
Received on
15/03/2024. That was received by the office of the this applicant, complainant, Lordship. And though the judgment and order
But you didn't have a special PP there before the CGM.
Lordship, I was special PP.
Oh, you appeared.
Yes, I've traveled to the Champai because during that time I was the sole advocate in the state of Mizoram. And Lordship, in this regard, the impugned judgment and order was pronounced in an open court. However, the said judgment and award was sent through the courier to the office of the Assistant Commissioner Customs. That was there some 50 days delay. So we know that in the open court it was acquitted, but the judgment was not delivered on the day. So it was sent through courier.
No, but you didn't obtain a CTC.
CTC, Lordship,
At that
the usual practice is they have sent to the department so that we have study, we have do research. That is the usual practice. So there is due to that reason, 50 days had gone unintentionally.
Okay.
And that on 05/07/2024, the Office of the Assistant Commissioner, Customs Division issued a letter dated 05/07/2024 requesting for legal opinion to the Departmental Council. However, owing to court closure from 08/07/2024 to 17/07/2024, the letter was received by the Departmental Council on 23/07/2024, and as such, 180 days had gone unintentionally from the date of judgment and order. Lordship, during that day, 8/7/2024 to 17/7/2024 was the court holiday, and during that period, the office of the Departmental Council was also closed. So I have annexed a copy of the letter, which is at page 26. And see that the counsel for the applicant took 16 days for drafting, and pursuant to request, the Department Council dispatched the legal opinion dated 08/08/2024 to the Office of the Assistant Commissioner, Customs Division. However, as per the record, the said legal opinion dated 08/08/2024 was received by the Office of Assistant Commissioner, Customs Division, Aizawl, on 09/08/2024, and as such, 197 days has gone inadvertently from the judgment and order dated 25/1/2024. And again, I have annexed the legal opinion which was issued by me, Lordship, which is at page 27. That following the receipt of the legal opinion to the Office of the Assistant Commissioner, Customs Division, Customs Department, the competent authority has approved the grounds of appeal that is formulated by the Department Special PP against the impugned judgment and order dated 25/01/2024 on 16/4/2025, which was received by the Departmental Council on 19/04/2025, wherein the following days, starting from 20/4/2025 and 21/4/2025, was a holiday, resulting in an intentional delay of 452 days from the date of judgment and order dated 25/01/2024. I have annexed the approval letter from the competent authority, which is at page 30. Lordship, Annex 4 is at page 30. That the Departmental Council again took leave due to family issues, for which he had submitted his letter of absence to this Honorable Court from 22/04/2025 to 25/4/2025, and the following days, that is 26/4/2025 and 27/4/2025, being Saturday and Sunday, an inadvertent lapse of 458 days had occurred. I have annexed the cost list wherein my name has been clearly reflected, because I have submitted a letter of absence during that day. The Departmental Council took 2 weeks, that is 28/4/2025 to 09/05/2025, for finalizing, photocopying, and compiling the necessary documents. That 10/05/2025 and 11/05/2025, being Saturday and Sunday, and 12/05/2025, coincide with holiday, Buddha Purnima. The Departmental Council can only forward the instant application to the concerned department for their approval on 13/05/2025. As such, 474 days had gone unintentionally from the date of judgment and order. I have annexed, which is at page 32, Lordship, forwarding letter. That on 10/07/2025, the competent authority had approved the draft appeal and sent the letter dated 10/07/2025 to the Departmental Council, wherein the Departmental Council had received the approval letter from the Customs Division, Aizawl, on 17/5/2025. As such, 537 days had gone unintentionally from the date of judgment and order dated 25/10/2024. Approval letter is annexed at Annex 7, which is at page 33. That starting from 16/7/2025, the Departmental Council make necessary corrections in the application for continuation of delay, along with the main criminal appeal in the connected case, which took him around 2 weeks and was finalized on 1/8/2025. The Departmental Council forwarded the draft application for continuation of delay on 01/08/2025. However, the department had received the forwarded letter on 04/08/2025 since 02/08/2025 and 03/08/2025 are Saturday and Sunday respectively. Hence, a period of 557 days had gone inadvertently from the date of judgment and order, dated 25/01/2024. A copy of forwarding letter, which is at Annex 8, page 34, also. That on 18/8/2025, the department had approved the draft continuation of delay and forwarded the approval letter, dated 18/08/2025 to the Departmental Council, which was received on the same day, that is 18/08/2025. Hence, a period of 571 days had gone inadvertently. Approval letter is at Annex 9, which is at page 35. Starting from 19/08/2025, the Departmental Council had further preparing the necessary application for filing the said criminal appeal, such as special leave application, which is mandatory in filing a criminal appeal as per law. Thereafter, the Departmental Council took about 2 weeks for finalizing, compiling, xeroxing, etc. the said application, which was completed on 02/09/2025. As such, a period of 586 days had lapsed, and intentionally from the date of judgment and order such and such, that as per Section 4195 of BNSS 2023, the prescribed period for filing a special leave before this honorable court is 180 days, Lordship, as per 4195 of the BNSS. After applying the said section, the total number of days delay is 406 days till today, that is the date of filing, 02/09/2025. That the above sequence of events clearly indicates that there was no intentional or willful negligence on the part of the applicant in filing the appeal belatedly, Lordship. And Lordship, there will not be a prejudice to the respondent, because this is appeal against the acquittal. Lordship. And if the that continuation of delay is not allowed, and the good case of the Union of India will go on, in Lordship.
Yes, any objections?
My main objection is that the delay has occasioned due to the negligence and the non-persistent action of the appellant. So basically, my lord, I will base my argument on two citations. That is the 2012 3 SCC 563. Paragraph 28, madam. Allow me to read, madam.
Yes.
Though we are conscious of the fact that in a matter of condonation of delay, when there was no gross negligence or deliberate inaction or lack of bona fides, a liberal concession has to be adopted to advance substantial justice. We are of the view that in the facts and circumstances, the department cannot take advantage of various earlier decisions. The claim on account of impersonal machinery and inherited bureaucratic methodology of making several notes cannot be accepted in view of the modern technologies being used and available. The law of limitation undoubtedly binds everybody, including the government. In our view, it is the right time to inform all the government bodies, their agencies and instrumentalities that unless they have reasonable and acceptable explanation for the delay and there was bona fide effort, there is no need to accept the usual explanation that the file was kept pending for several months, years due to considerable degree of procedure, red tape in the process. The government departments are under a special obligation to ensure that they perform their duties with diligence and commitment. Condonation of delay is an exception and should not be used as an anticipated benefit for the government departments. The law shelters everyone under the same light and should not be swirled for the benefit of a few. In this case, my lord, as observed rightly by the Supreme Court, despite available modern technology, letters requesting for legal opinions has been resorted to. And my lord, the office of the Assistant Commissioner is, I think, roughly around 3 kilometers from here. Both, I'm not prejudicing the council, but my lord, both the council and the Assistant Commissioner has their office at the heart of the city. So they can exchange their
There's another judgment, recent judgment regarding delay. You don't have that, where they said that government authorities as well as private parties should be treated.
Yes, I have that one also, my lord.
Also, I have 4 citations also. I may be allowed to submit after finishing this.
Yes, my lord.
Yes.
And coming on to the grounds, my lord, the council. Firstly, I would like to state that the council was duly present, and I have annexed an order sheet in my written objection as well. And even though the council had contended that the same was received only on the 15/3, my lord, that contention cannot be said to be bona fide, because the signature bears only the signature of the Assistant Commissioner.
That's why I was asking the council also, no, whether he was present.
Correct. The councils were duly present, my lord. The order sheet has been annexed in my WO written objection. And my lord, at point B, the ground stated at point B, my lord, at page 10 of the application, there was initially 50 days. 50 days delay was mentioned, and after that, my lord, the legal opinion, owing to the letter was received by the council on the approved legal opinion was received by the council on 23/07/2024. There was no explanation of for the reasons between
15/3 to 5/7.
5/7/2024. Yes, my lord. And
4 months, in fact.
Correct.
3,
my
4,
lord.
5, 6, 7. 4 months.
And at point D, my lord, page 11, that following the receipt of the legal opinion to the office of the Assistant Commissioner, Customs Division, Customs Department, the competent authority has approved the grounds of appeal against the impugned judgment and order dated 25/1/2024 on 16/4/2025, which was received by the Department Council on 19/4/2025. My lord, the 16/4/2025 has to be a crucial date. It's a crucial date because almost a year has lapsed.
Yes.
And no proper explanation has been given, my lord, except for the. I'm not raising my objection against the time taken by the council, but my lord, the
legal opinion was sent on 8/8/2024.
correct.
8/8/2024, and the approval came on 16/4/2025.
Yes, after almost a year, my lord.
Yes.
And my lord, at point F, just a mere objection that there is no bar for the council to forward the concerned letters to the respondent, to the appellant authorities. And in fact, my lord, as I have mentioned, electronic modes can be resorted also in this utilizing the advancement in technology. So
At F, you are pointing out which one? 2 weeks, this one, for finalizing, photocopying and compiling.
yes, my lord. The council has stated the hardships on the weekends, but as I have mentioned.
No, that is okay.
Yes.
That is. But the main thing is this, between 15/3/24 to 5/7/24. And another one is from 8/8/24 to 16/4/25.
Correct.
There is no explanation whatsoever, because as far as lapses of the council is concerned, that the court may condone. But regarding the lapses by the applicant themselves, that is a bit difficult, you know. I think you'll have to file an additional affidavit.
My Lord, in that regard, my Lord, I would like to point one citation, 2022, 16 SCC 483. Here, my Lord, the state of Bihar has filed an appeal against the order of the learned single judge before the division bench after a delay of 365 days. And the observation is that, I'll just read out, my Lord. We are of the view that at Paratu, we are of the view that a clear signal has to be sent to the government authorities that they cannot approach the court as and when they please on account of gross incompetence of their officers, and that too without taking any action against the officers concerned. No detail of this delay of 728 days has been given, as if there is an inherent right to seek condonation of delay by the state government. The law of limitation apparently does not apply to the state government according to its conduct. That such condonation of delay is no more admissible on the pretext of government working liturgy is clear from the judgment of this court in Postmaster General versus Living Media India Limited, the first citation which I mentioned. So, my Lord, a positive discretion cannot be is unwarranted in this case.
The application as it stands, I don't think we can condone, but I think we'll give them an opportunity to file an additional affidavit.
My Lord,
just one opportunity. And if you're not able to explain, then we have to dismiss it. Because this delay in between 15/3 to 5/7/24 and 8/8/24 to 16/4/25 is not explained at all.
I'm with you, Lordship. Yes,
it's not explained at all. And this is not the delay caused by the council. This is their delay, the applicant's delay.
Lordship, since the applicant is the state and
that's where
it
we're
is well
saying,
known that there is from table to
but
table.
But still,
yes.
some form of explanation has to be there. But here, there's nothing.
Very true, Lordship, yes.
So if we give you an opportunity, will you be able to explain this delay? Otherwise, we'll have to dismiss it.
I agree, Lordship, yes.
Yes.
My Lord,
okay.
May I just mention that the present application has been amended. The respondent had not invoked Section 5 of the Limitation Act, and accordingly it was allowed by the court.
So this is an amended application?
Yes, my Lord. And objections have been filed, my Lord, but I'm just saying that there was ample time, if at all they have their objections ready for filing.
I'll write to the department in Lordship if chance was given, and yes, I understand. Yeah, I have seen.
Because on technicalities, this court also doesn't want to dismiss. But on the other hand, when such a glaring gap is there in between, then what can the court say about that?
Yes. And besides, this is the cause of the record.
Okay, just say, upon hearing the counsel for the parties, this court is of the view that the applicant has not been able to explain the delay with regard to the time in between the receipt of the judgment and order by the applicant on 15/3/2024 and the letter dated 5/7/2024 issued by the applicant to the council seeking for legal opinion. There is also no explanation regarding the delay in between the dispatch of the legal opinion on 8/8/2024 and 16/4/2024, on which date the applicant has approved the grounds of appeal. Stop. In view of the same, the applicant is allowed to file an additional affidavit to explain the delay with regard to this time. Just say with regard to the time frame as mentioned above. Okay. The same shall be filed within 2 weeks.
2 weeks, Lordship.
Within 2 weeks. So please after 2 weeks. Okay. Let's see after that.
Yes.
Item 12.
My Lord, I'm appearing on behalf of my senior, Mr. Bilaram Enga. He has personal difficulty today, so if this matter may kindly be taken up tomorrow.
Tomorrow.
Yes, my Lord.
Is this coming up for the first time today?
Yes, my Lord.
But in any case, the respondents have to obtain the case diary. So we'll just fix it next week and then ask them to get the case diary. Is that okay? I think that will be better, because tomorrow also, as it is, we will not be able to dispose it off without producing the case diary, even if it comes up tomorrow.
But my Lord, I have the instruction to request your Lordship to fix it tomorrow.
Then on the prayer of the Learned Council, Ms. Such and Such, praying on behalf of the senior.
Yes, my Lord. Mr.
Senior,
Bilaram
Mr.
Enga.
Such and Such, pass over for the day. Okay.
Item 7.
This is hearing. Oh, that Passover matter, no?
My Lord.
Yes.
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 It seems
no affidavits.
No, my Lord. There is one thing. The respondent number 5, Kala. Even though they are just a proper party, my Lord, they have received the notice. Notice is even though complete, they haven't yet filed their.
They are not appearing.
Yes. Vakalat nama. They have not yet filed vakalat.
Oh, not yet filed vakalat nama.
So.
May it please, Your Lordship, I have been instructed verbally and I will be executing the vakalatnama by next week, Your Lordship.
Okay. For R5.
Yes, madam.
Yes. Learned Counsel for the petitioner, Mr. Sessions is present. Stop. Learned Government Advocate, Ms.
Lalnunlu, Your Lordship.
Prays for 2 weeks.
Your Lordship, if 3 weeks may be granted, Your Lordship.
3 weeks time to file the vakalatnama as well as the affidavit on behalf of respondent number 5. So, the other respondents have filed? Respondent number 2
respondent 3 and 4.
has filed the affidavit. And respondent number 1 is represented by CGC, Ms. Such and Such. Stop. Respondent number 2, 3 and 4 is represented by Such and Such. So, list after 3 weeks as prayed for.
License.